Hello friends, Namaskaram, how are you? Myself is Dr. Jineesh Soni. I am an advocate and a defense counsel. In today's class, I will explain you the importance of Section 141 of NI Act, and in case you are having the trouble of Section 141 of NI Act, then how you could contest and could effectively submit your defense. So directly we are moving on the board. In a check bounce case, as we know that the burden is on the shoulders of complainant. If complainant prima facie put up the element, in that scenario, the court may draw the presumption. But presumption is not the conclusive proof. Even the presumption could be refuted. Regarding this, the defense is not required to prove the scenario beyond reasonable doubt. The defense must be on the point of probable defense so that probabilizing effect could be on record. A defense could be probabilizing in nature if it is going to create a suspect, it is justified, and corroborations are on record. For example, Mr. A says that I have given rupees 2 lakh to Mr. B. To repay the amount, check is given. Mr. B says that 2 lakh rupees are repaid or certain amount is repaid in part prior to check bounce. The fat is not in roast. So basically, Mr. B is going to put a suspect on legal enforceable debt. And that's why the defense could be said to have the probabilizing effect. In that scenario, Mr. B will be succeeded. But in addition to this, we have to understand Section 141 of NI Act that says that if there is any prosecution against the company, Section 141 of NI Act must be complied with. The protocol is mandatory. If there is any diversion, in that scenario, the case will fail. Please be noted an important judgment on point of Section 141 of NI Act, that is Gujarat High Court judgment. Title is Rakhi versus State. Judgment date is 24th of Jan 2025. In that case, court observed that Section 141 of NI Act is mandatory. If there is non-compliance, the accused could have the benefit. In the present case at hand, the proceedings were challenged by one of the accused who had been arraigned on point that his director of the company, he submitted the following important points. Number one, there is no compliance of Section 141 of NI Act. Apart from that, the consent check is not signed by him. The check is bounced in the year of 2017 while he resigned from the company in the year of 2013. So he submitted that when the offense was committed, he was not holding the position of director. To prosecute director, the prime condition is that there must be averment that the concerned person is responsible to conduct the affair of the company. If the averments are missing and there is no specific corroboration in that scenario, the case will fail. Apart from that, the accused relied on two important judgments, that is 2009 volume 4 SCC page 683, 2012 EIR Supreme Court page 2795. In both the cases, it is specified that Section 141 of NI Act is mandatory. If there is non-compliance in that scenario, the accused could have the benefit. So the court observed in that case there is non-compliance and finally quashed the proceeding. So the said judgment inter alia provides us the five important way to contest a check bounce case. Number one, if the company is an accused, in that scenario, the director could be prosecuted if there is specific averment with corroboration that the director is responsible to conduct the day-to-day affair of the company. Number two, specific proof regarding compliance of Section 141 must be on record. If there is no averment or there is non-compliance, then accused could have the benefit. And whenever there is a notice to the company, the notice must be to director also. If there is non-compliance, then the accused could have the benefit. And if the director are arraigned as party, but company is not arraigned, in that scenario, accused could have the benefit. So I think that I've specified you the importance of Section 141 of NI Act. So if you're having the resembling issue, try to apply the said principle so that you could be succeeded accordingly. So there is nothing to worry about. Offense is totally technical in nature. It depends upon us in which manner we are going to contest. And that's why I always recommend to do the review of the case so that effective points could be on record. With the help of them, you could have the proper defense line and finally you could be succeeded accordingly in your case. See you in the next lecture.